Yes, thank you. Sadly, I'm sorry, I was just checking that I brought the authorities bundle back. I thought this was the moment to make sure before everyone who could help me had disappeared. Mr. Jordan.
Yes. To answer the question raised immediately before the short adjournment, we have an exchange of emails for the court. If the court could turn to the second page and look about 2/3 of the way down, that's the first email. This was sent on Thursday, the 29th of June, a week before the hearing began. Perhaps the court could read that.
Right, and this is from...
This is from David Mander at My Instructing Solicitors to Mr. Ashley Marks, solicitor at the City of Manchester. And Mr. Marks's reply appears at the top of the page.
And the document attached is the...
Yes.
Is
the document attached we have provided. It is the same wording as the court has seen, but it's got a different heading, agreed stroke applicant's proposed modification wording, but the wording is the same. And then the other document is page 3 of the transcript for day 1 of the hearing, where the highlighted passage shows Mr. Hutchings saying you should have the proposed modified wording, which is somewhere in the pile, loose. And so the position is it was sent to the council a week before the hearing with an invitation that they agree it or change the wording if they disagreed with it. They said they weren't going to engage with that. And then was given to the tribunal at the start of the hearing.
Only again, in the unlikely event that your plan is successful. It's day 1, the transcript's day 1 of the hearing.
Yes, my lord. There's just one point I should have made this morning. Perhaps I can just make it briefly now. The new lease would, of course, have required the payment of a premium. That's what the council said, and indeed it's obvious because it would be a lot more valuable than a 60-year lease. So although it's certainly true that the tribunal made a finding that the council's concern wasn't only money, there undoubtedly was a premium to be paid for the new lease. So that, in my submission, supports my submission based on the Stockport case, but this is the same. It's not purely money, but it is money plus, and no different approach should be applicable.
Thank you. Mr. Moorshead.
May it please your ladyship, I do need, in fairness to my clients, to start by reminding the court about the context for this. This is an important landmark site in Manchester, with implications not just for my client as an individual, but in its capacity as guardian of the public interest, as guardian in a meaningful sense of the City of Manchester. It's part of an area which is the subject of an ambitious programme for redevelopment. It's called Plot G in that scheme. Other plots have different labels, but they've all got a job to play in the overall programme of redevelopment, which is underway. Scale is important in this case. The estimated cost of completing the development of Plot G has been put at figures ranging in the papers between 300 and 400 million pounds. That is a significant factor to bear in mind. This is not one of those cases in which the proposed modification or discharge is to allow somebody's neighbour to build an extension on the back of a house, where it's obvious that if that's what the neighbour wants to do, it can happen. This is a case where the programme of development depends on there being liquid funds available to complete the programme. And because of the scale involved, that question is not a foregone conclusion. And the reason it's not a foregone conclusion is because this lease is only for a relatively short period of time. 60 years contractually. There is power to renew, but only once the redevelopment has taken place, and only if the development was with my client's consent. So there's a whole question about whether the 60 years could be extended at all. If it could be extended, it would only be for another, I forget the exact number, 24, 26
15?
years, something
Was
like
it
that.
15 years?
15 years. Nowhere near the 250 years, which are under discussion as the vehicle for regearing. Because of the scale of what is proposed, this development comes with a particular level of risk.
26 years.
20, I thought it was. So this, in fact, is acknowledged by the appellant in its skeleton argument. You'll remember Mr. Jordan referred to it orally this morning when he was explaining why his client resists a forfeiture provision. He was saying, well, what if we spent £250 million, but we're still short of the funds needed to complete? Precisely our point. That is precisely our point. This is a big development site with big sums of money at stake. Even if we take entirely at face value that this appellant is fully committed to redevelopment, come what may, it will put in whatever resources it can muster to bring about the development. Even then, by accident, the development might remain uncompleted, in which case, if the appellant succeeds, we will have no remedy. This development site has the potential to remain undeveloped and a blot on the landscape for a generation until the end of the lease. And that's assuming, in the appellant's favour, that this litigation is not part of a negotiating strategy. The strategy being, we need at least enough authority and sanction to go on and demolish the buildings. Because once we've done that, we've got the council over the barrel when it comes to the terms of the new lease. Because the council will have to give us whatever we ask for so that this site doesn't remain a derelict wasteland for the remaining 60 years of the lease.
Does it make any difference whether you have some 1970s redundant warehouses or a vacant plot?
It may well do. It may well do. There may be different levels of hazard associated with the two kinds of site. There may be different levels of eyesore associated with the sites. At the moment, the buildings are subject to the covenant to keep in repair. So there will come a point beyond which any deterioration at the moment can be guarded against. So there is a cap on the extent to which the existing structures can be allowed to deteriorate to become a colossal eyesore in this gateway site. What's proposed by the appellant is a situation emerging in which even that control is gone. And these buildings, which everybody is looking to replace, might simply be knocked down and an empty space eventuate. That is a legitimate concern in my submission. And I emphasize these points because in point of substance, as a matter of ordinary English, the covenants in this lease are protecting the council in the way I've described. As a matter of ordinary English, what I have described are practical benefits of substantial value or advantage. And that, I suggest, is the issue that is at the heart of this case and which was recognised by the upper tribunal and grappled with adequately. Milady, I'd like to start briefly by going through some of the authorities, not very many, not nearly as many as my learned friend, after looking at the Act itself. Then I'll be looking at the upper tribunal's decision, and that will foreshorten my response to the appellant's what I'm calling ground 2, the Stockport argument. And then I will deal with the what I'm calling the 1C point. And then I anticipate that the next stage, if this is agreeable to your ladyship, will be that we will interrupt my submissions and hear, presumably briefly, from Ms. Tivcott on the compensation question, which is one aspect of our respondent status. I will then stand up again and address the court on the causation issue, again I hope briefly, and then I will address you finally on discretion, if that sounds like a convenient roadmap. I'm likely to come, even more likely than usual, to come a cropper, because I have, consistently with the spirited pace of Mr. Jordan, I have attempted to compress what I wanted to say, and I'm hopeful that I will be successful. It does carry the risk that I might trip up even more than is typical for me when addressing the court. Can I start then by going back to section 84?
Can I ask a question from the nomenclature? You referred to something called ground 2. I thought ground 2 was the discretion argument. So are we at cross purposes?
I'm content to call it, I think I'm content to call it that, but we might be at cross purposes, and it might just be a nomenclature point. It's the point that's referred to in, I think, paragraph 27.2 of my learned friend's skeleton argument, and developed by him in...
I had a very simple view that ground 1 was jurisdiction and ground 2 was discretion. But
I'm not sure
that may be wrong.
Going to be maybe a convenient way to think about it, but I'm not sure that's quite how... In fact, what I was about to say in relation to section 84 may be a convenient point at which to make this submission, if I may.
Ground 1 has 2 aspects, doesn't it, as it's been developed by Mr. Jordan?
That's a...
So I think that was sort of maybe 1A and 1B, and then 2 is what we've thought of as discretion. But
that may be the fair way.
Doesn't matter, really, does it?
That's probably the fair way. Section 84 then. There are really 3 features of note I'd like to call to the court's attention by way of emphasis. The first is to respectfully pick up on what emerged in argument between my Lord Justice Baker and Mr. Jordan about this word impede.
About what, sorry?
Impede, the word
Impede, oh yes, impede.
And the facts of this case illustrate the importance of the point. The court will remember that classically section 84 applies to restrictive covenants in the context of freehold land. But there is jurisdiction to modify leasehold covenants as well.
12.
But a leasehold covenant is distinct from a freehold covenant in that, of course, it's going to be a different question in each case about how much of the lease remains. How much of the lease remains. And you'll see from the controlling provision in subsection 12, which is at page 11, you'll see what has to happen before a tenant can apply. And there are only 2 requirements. The lease has to be for more than 40 years, and the first 25 of them have to have expired. What that tells you is that you can apply as close to the end of the lease as you like. There's no limit based on how much of the lease remains. And I suggest that's an important feature of the jurisdiction. And we can expose it by reference to the facts of this case by taking a hypothetical example. In this case, we know that the term of the lease is 60 years or so. It's the residue. But suppose it were only a year. There's nothing in the Act to stop the applicant coming forward. But in that situation, equally, the applicant has no right to a new lease. It has no contractual right to call on my client to grant it a new lease. If it gets a new lease, that's because it's negotiated. So imagine this case coming forward when instead of there being 60 years left, there was only 1 year left. Nothing could be done in that time except clearing the site, demolishing the buildings. On my learned friend's approach, nevertheless, the tribunal should agree to discharge or modify the covenant. Because if, in a different version of reality, the end product were somehow to be produced, that would be a reasonable user of the land. That is not a sustainable outcome. That is an incoherent outcome, and it's a very strong indication that Malone Friend's interpretation is fundamentally misconceived. Impede means what it says. It is enough for me to show that the covenants are doing something of practical benefit that's substantial now. That they will be useful now. It doesn't mean that no event can ever happen in the future beyond which they will cease to be useful. It's sufficient for me that they are useful now. Or putting it the other way around, it may well be that the use the applicant desires to bring about, and which we equally desire to bring about, is a reasonable end product. That doesn't mean that these covenants are not serving practical benefit of substantial value and advantage for now. The time is not yet ready. And we'll see the significance of this when we go into the upper tribunal's reasoning. I know my lady Justice Asplin was in argument observing the significance of paragraph 33, including the word until. And if I may say so, the Ladyship was entirely right to have drawn attention to that aspect of the matter, and all I'm doing with this submission is cementing that point in the statute itself. The second point of materiality is that the jurisdiction conferred by subsection 1 is one that arises only on the application of the person interested in freehold land, obviously leasehold in an appropriate case. That's the only jurisdiction the tribunal has. It can only modify on the applicant's application. And that tells you why my learned friend's argument about subsection 1c is wrong too. Because when you go to subsection 1c, this is the third point, what you find is not a freestanding provision that empowers the tribunal to attach conditions. The way it works is to declare that the power in section 84.1 includes the power to attach conditions. What that tells you is that if the applicant applies for modification or discharge, then he or she may apply for that modification or discharge, in fact only modification, section 1c only applies to modification. He or she may apply for the modification to be attached with conditions. That's how section 84 works. As you would expect, what an exercise in sheer futility it would be to expect a respondent, an objector, to come up with the conditions that it says has to be satisfied, only for them to be shot down by the applicant, rather than the applicant coming forward with the conditions that it says will meet the objector's concerns and having a debate about those.
But you're not saying that the tribunal of its own volition can't suggest conditions as things unfold?
Of course. But what happens when that occurs, my lady, is in compressed form what happens is the tribunal suggests something, the applicant will then adopt it, and it becomes part of their application. That's how that works. But that's just a compressed form of doing what the Act requires. I'm not saying that any particular form is required.
Presumably a respondent would suggest conditions.
Yeah, of course. Yeah. But Malone Friend's argument needs to criticise us for not having identified conditions that would have met our concerns. Our brief answer on that is, so far as we can see, there aren't any. So far as we can see, there is no way to overcome the viability issues. So there isn't a condition we can come up with. I'm going to show the court some of the pleadings where this emerges, but we haven't said to the applicant, if you really think there's a way of addressing our concerns through conditions, show us. We've not said that. So those were the 3 points that I suggested it might be helpful for the court to have in mind about section 84. The next submission I make is by reference to authority, because your ladyship will have recalled from the skeleton arguments and from the tribunal's approach and some of the decisions that have been cited, that there is in the background this case called Rebath, which sets out a structured approach to the questions that arise potentially under section 84. And it's a decision only of the upper tribunal, or the lands tribunal. It's not a binding decision. So far as I'm aware, it's not received any sort of explicit sanction by a higher court as being a definitive and controlling description of what section 84 contains. It's a checklist, a useful checklist. Nevertheless, it was common ground between the parties that that was the checklist by which it was appropriate for the upper tribunal to approach its consideration of the issues in this case. The 7 questions which potentially arise are set out in my client's skeleton argument before the upper tribunal, at paragraph 14, which is in the bundle at page 90, the supplemental bundle, page 93. The applicant, at that time, the territory is so familiar within this specialist jurisdiction that Mr. Hutchings didn't separately list them, but he said in his skeleton argument at paragraphs 50 and 52 that he was following because they are conventional. And then he asks, in fact, the questions that do arise under Rebath. So all of that was well understood by the parties. It's well understood in the upper tribunal, and so it isn't always spelled out in every decision. But for the court's note, I don't think it's productive to take up time showing you the authorities. But Preston and Newsom, 1323, authorities bundle, page 32. A case called Medley and Mackenzie in the upper tribunal at page 231 in the authorities bundle. And O'Byrne, which I might come back to for a different reason, at page 267 in the authorities bundle, are just examples of how the tribunal has used this checklist and found it helpful as a way of structuring its approach to decision-making under section 84. And I think Judge Elizabeth Cook, in the Medley and Mackenzie case, pointed out that it was a useful checklist because, without it, section 84AA is a bit complicated because it's entwined with subsection 1, capital A. My next submission is about the Stockport principle. And if I may say so, I respectfully agree with my learned friend's analysis of that decision. It's unfortunate in a way because it would be really helpful to have a binding decision from this court that Lord Justice Eveley's analysis is analytically the correct one. I can't, in good faith, though, argue against that proposition, so it will have to go as an unargued point. But it is clearly correct because the question of whether a benefit is practical is obviously a pure factual question. The only way to limit its ambit in a way that serves the statutory purpose is the way identified by Lord Justice Eveley. It's to recognise that what has to be, and the way I would perhaps put it is that a benefit which only results from a discharge of the covenant, such as negotiating a preferential fee or negotiating other preferential terms of a lease, in return for the discharge of a covenant, does not count. No matter how practical a benefit might be, it's only relevant if it results from compliance with the covenants, which I think is just a longer worded way of agreeing with what Mr. Jordan said. I agree with that. But note the limits of that principle. On the facts of our case. Protecting Plot G from a risk of incomplete development is a benefit that flows from compliance with the covenants, not their discharge. Now, we hope that the protection afforded by the restrictive covenants will only be needed until a new lease is negotiated. This is my Lady Justice Asplin's point. But that might not happen. Or it might not happen soon. And in the meantime, the covenants are doing exactly what they were meant to do. And that's enough. The next authority I wanted to mention is adjectival to that point. Subject to the stock court principle, which I've now summarised in agreement with Mr. Jordan, the concept of practical benefit is deliberately broad, and the court has resisted attempts to add any gloss. Gilbert and Spohr is the leading authority. Rather than turn that up separately, the relevant passage was endorsed by Lord Justice Carnwath in Shepherd and Turner, which I would like to go to, please, in the authorities bundle starting at page 316. Where your Ladyship will see, starting at paragraph 18, the court, says Lord Justice Carnwath, emphasised the width of the considerations which may be taken into account when considering whether a covenant secures a benefit of practical advantage and substantiality.
Sorry, which paragraph were you then reading from?
18, my lord, bottom of page 316.
Sorry.
I probably gave a wrong reference, sorry. And then is quoted the extract from Lord Justice Eveley's judgment that I rely on. And it is perhaps notable that Lord Justice Carnwath included the last sentence. It's not mere rhetoric. When one remembers that Parliament is authorising the Lands Tribunal to take away from a person a vested right, either in law or in equity, it is not surprising that the Tribunal is required to consider the adverse effect upon a broad basis. Could I then invite the court to consider paragraph 23 at page 3.1. I suppose, in fairness, I need to go back to paragraph 21, 317, with the sideline paragraph, where you'll see that Lord Justice Carnwath is slightly critical of the member for being over-elaborate in his approach to the interpretation of the section. And in paragraph 22, he uses a sort of adopts what's basically a layman's definition of substantial. And in paragraph 23, he says, I agree that this is a safer guide, and I pray this in aid to the court when considering how to interpret section 84. I would prefer not to seek a substitute for the statutory language, nor to seek a degree of precision which Parliament has avoided. It was no doubt thought appropriate to leave it to the tribunal as an expert body with the statutory function of promoting uniformity of decision to apply the section in a common sense way. That is very much, if I may say so, the approach one would expect from Lord Justice Carnwath, Lord Carnwath as he became, of course, a very grounded, pragmatic understanding about how these tribunals work, what they're for. It is a common sense jurisdiction. It's not meant to be picked apart, which is why I slightly quail from a rigid distinction between jurisdiction stages and discretionary stages. I slightly quail from it. It is a valuable shorthand. I accept that. But all the questions that arise are evaluative questions. They're all evaluative. And the evaluation of all the questions is entrusted to the upper tribunal, which this court will only intervene with on conventional Aldis principles. Irrelevant considerations, that sort of
Conventional what principles?
Aldis. I'll do it from Shepherd and Turner. You see how Lord Justice Carnwath deals with it in this case. We see, for example, from paragraph 28, asking himself, or 27 and 28, asking himself whether the tribunal had a point in mind. And then in 28, finding it hard to see in what way it said the tribunal applied the wrong test, took the issue into account. How he did so was a matter not of law, but of professional judgment on the facts. Consideration could only be in general terms, since the specific effects would depend on the nature of a particular proposal and so on, by reference to the particular facts of the case. And 29, to summarise, the thin end of the wedge argument is relevant, but the issues it raises are ones of fact, not law. The tribunal considered the issue. That is the requirement, where the tribunal is entrusted with evaluative questions of this kind. And likewise in paragraph 41, this is what my note tells me, go to next on page 322. Referring to some dicta of the then presidential department in the Lands Tribunal in Fairclough Homes, and expressing qualified agreement with them, central to it is the need to evaluate the practical benefits by reference to the nature and purpose of the particular restrictions, which in that case is obvious on their face. The purpose of the present restrictions is also apparent on their face, some is preserved and so on, by reference to the facts of that case. The court can see, reading on towards the bottom of paragraph 41 and paragraph 42, that what Lord Justice Carnwath is testing for is whether the tribunal had regard to irrelevant factors or ignored relevant factors. The question of weight being a matter for the tribunal. And on balance, Lord Justice Carnwath accepts that that is what the tribunal had done. The tribunal had not excluded a relevant factor, it had included it and given it limited weight, as he was entitled to do. And then the final paragraph in my note, which I suggest I invite the court to read, is paragraph 61. Maybe the court could, while we're on this sort of section, cast its eye over 57 and 58 as well, but I'm going to come to 61. Because in paragraph 61, you see how forgiving is the approach the court is required to take. Because this is an evaluative jurisdiction, specialist tribunal. It's a fair criticism of the tribunal that there's no analysis of the conflicting evidence on the extent of the construction works. On the other hand, the surveyor member was well able to form a view as to whether there was anything exceptional about the site or the proposed works, to treat this as a factor justifying refusal or modification. The reasoning could have been more fully expressed, but that by itself does not mean that the decision is erroneous. As I said in rail track, a failure of reasoning may not in itself establish an error of law, but it may indicate that the tribunal never properly considered the matter and that the proper thought processes have not been gone through. In this case, in my view, there's nothing to show that this experienced tribunal member did not fully understand the issue before him, or that his decision is flawed in law. There's no presumption that the tribunal has to show fully its working. There's no presumption that absent it being fully worked out, the tribunal has committed an error of law. That has to be the proper inference. It's not assumed in favour of an appellant in this court. And finally, I need to show the Court the decision of the Supreme Court, which is the only time this jurisdiction has come to the High Court, in the case of Alexander Devine, which starts at page 67 of the Bible. Mr. Jordan explained this to and at paragraph 33, he referred to the Driscoll case and said it's well established that if satisfied that one of the prescribed grounds has been made out, the upper tribunal has a discretion whether or not to make an order for modification or discharge the restrictive covenant. The important statutory words to this effect are in section 84.1, the upper tribunal shall have power. The 5 grounds are therefore concerned with establishing the upper tribunal's jurisdiction and can helpfully be labelled the jurisdictional grounds. I agree with that way of putting it. It is a helpful label, but it mustn't be overlooked that just because the word discretion is used in one part of the labelling, it doesn't follow that discretion has no part to play in the jurisdictional ground. The jurisdictional ground is no less evaluative than the discretionary ground, including the question of evaluating, well, are these benefits practical? If they're practical, are they substantial? That is an evaluative question. Merely because it's not one falling under the discretionary limb doesn't make it any less evaluative. With those principles in mind, I invite the Court to return with me to the upper tribunal's decision itself. And the passage I'd like to start with is one that was not read by Mr. Jordan, despite it having been flagged up in my supplemental statement argument for this Court. It's paragraph 42 in page 120 of the Court bundle. And just to help the Court locate where this passage belongs in the cases, it's where the tribunal is dealing with ground A. Ground A applies where an applicant can show that a covenant is obsolete, that it no longer serves its intended purpose. The way my client showed that the covenants were not obsolete was to say they are still securing these important practical benefits. And the tribunal accepted that submission, as you see, from paragraph 42. In any event, we have no doubt that the Council's aim in the negotiations is not a purely commercial one. It has a legitimate strategic interest in continuing to influence the use of land on the floor of the city centre and to secure its orderly and appropriate development. That interest is promoted through the statutory planning process, but there is no reason why its promotion and protection must end there. And the leasehold covenants allow it a further opportunity to control the use of the site. The evidence of Mr. Ken Richards, the Council's principal development surveyor, fully satisfied us that the Council wishes to ensure that development of the site takes place in the manner proposed by the applicant, subject to appropriate safeguards, to ensure that it is commenced in a timely fashion and not left incomplete. That objective is plainly in the interests of the public of Manchester, and its achievement is a facet of the control over the use of the site which the covenants were intended to allow the Council. 3 points about submissions about that passage, please. First, that is an appraisal of the substance of the Council's concerns. It's not a mere deference to the Council having genuine worries that were unsubstantial. That whole passage is predicated on those concerns being ones of substance. That's what legitimate means. Secondly, none of that has anything to do with the prospect of a new lease or protecting the council's negotiating position. Literally nothing. Third point, it's not being challenged. No part of the Land Friends appeal to challenge any part of Ground A, including that paragraph. And if we're now to hear something about paragraph 42, it'll be a bit late, because I won't have the opportunity to reply to it. So, what stopped the covenants from being obsolete was precisely that they continue to provide the practical benefit that I've described. This is an integral part of the Tribunal's decision, which you have to read as a whole. It explains why the Tribunal did not repeat itself later on in detail about what were the practical benefits. It had already explained them and made its unchallenged assessment about them. If we return then to the decision itself, I go next to paragraph 49, the foot of page 122, because I'm going to be partly critical of the other tribunal in relation to this paragraph, but for present purposes, that's not the focus of my submission. The suggested impracticability in this case does not depend on the prospects of planning permission being granted, but on the ability of the applicant to fund, manage and complete the development without securing a new longer lease. Without proper evidence on those issues, we're not prepared to form a judgment on the basis of mere assertions by one side or the other, given that both parties are keen to see the site developed for residential use, and that such use is in accordance with the development plan, we are satisfied that it is a reasonable use. The Tribunal then considers whether the restrictions impede the proposed use. It's satisfied that they do. And then in paragraph 51, it addresses itself, again, it's going through the Rebus checklist, more or less. The next question is whether by impeding the proposed use, the restrictions secure to the Council practical benefits, and if so, whether there is substantial value or advantage. I know the Court has already read this passage, but armed with the principles that I've reminded the Court about, I ask, where is the error of law in this evaluation? Bearing in mind that when reading this paragraph, one has to be informed by what the Tribunal has already said in paragraph 42. Reading paragraph 51 with paragraph 42, there can really be no doubt about it. The purpose of the provisions is to ensure the development is completed and within a reasonable time. In paragraph 52, the Tribunal reflects on the conditions as they had been formulated within the negotiations. And it rightly applies the Stockport principle. It accepts Mr. Hutchins's reliance on the Stockport principle. But it makes the point that Mr. Hutchins had misidentified what was the practical benefit that the Council was relying on. No doubt through that combination that sometimes happens in litigation of wishful thinking and Nelsonian blindness. Paragraph 53, as my Lady Justice Asplin has pointed out, is significant. The Council's ability to withhold its consent to the development of the site until, that's enough for my purposes, until it is satisfied that the applicant's proposals can be delivered, does not confer only peripheral or indirect benefits. Yes, the development is reasonable, that's what the Tribunal is saying. That's what we're saying. But not yet. Not yet. Because all the pieces in the jigsaw have not been put together. And if that weren't clear enough, the Tribunal goes on to return to the Stockport point. It would no doubt also be commercially desirable for a new longer lease to be granted to underpin the development and to enable the applicant to recoup its investment over a longer period, but that would be the case whether or not the restrictions in the current lease impeded development. The Council's negotiating position is not a benefit which it derives from the terms of the lease, or not from those terms alone, but from the fact that the lease will expire in only 60 years. And ... what it could have added was, and because the applicant has no contractual right to a new lease. Tribunal can't just invent one. Learned friend speaks as if it's a matter of neutrality, that the council is in a ransom position within the negotiations. That's a complete mischaracterisation of the situation. His client owns a wasting asset. If it wants to stop the wastage, it is the one that needs the consent of my client. His client is the supplicant. That's not because of the covenants. His client is intractably and inevitably in the posture of supplicant. And then likewise in paragraph 54, you see the Tribunal turns to the substantiality of those practical benefits, but it draws the strands together in paragraph 60. The general thrust of Mr. Davies' conclusions, reversion to two substantial residential buildings is likely to be more valuable than reversion to two redundant warehouses is not difficult to accept. Given the Council's witnesses' acceptance of that proposition, we need say little more about it. From the evidence, we're satisfied that measured in monetary terms, the restrictions do not, by impeding the development, secure to the Council practical benefit of substantial value. Whether the practical benefit is a substantial advantage, however, is a different question. The nub of this application is about the control the restrictions secure to the Council as a local authority. We're satisfied that the Council's concerns about the viability of the development are genuine, and the conditions that it seeks to impose address its wish to see the development commencing and being completed within a certain period. We have no view as to whether the proposed periods are realistic or reasonable, but that isn't the issue before us. The question is about the extent of the advantage which the restrictions secure for the Council by preventing the development going ahead unless, that word again, the applicant satisfies its concern. Not peculiar nature, but aimed at ensuring one of the last pieces of development jigsaw stops in its place, satisfied as is a substantial advantage, and the application therefore fails. Now, my learned friend, in an argument not foreshadowed in his skeleton argument, and for which therefore permission to appeal has not in fact been granted, now seeks to argue that when the upper tribunal was using words like genuine, it was doing so in a way that excluded the possibility that it also regarded the concerns as well-founded. There's no justification for that inference at all. The word genuine and its cognates is just as capable as many other words in our protean language of including a finding that the concerns are of substance and reality, as well as communicating the fact that they are actually held as distinct from being a pretext. And I've shown the court paragraph 42, from which it is clear the tribunal was directing itself correctly about whether the Council's concerns were legitimate. That's the word it used there.
So where is the word genuine being used in a way which you say demonstrably has that broad meaning and not just the narrow meaning for which you say Mr. Jordan was contending?
Well, I would say that where I'm looking now to where the word pops up. Is it
in 60, it starts the nub, and then the next sentence, we're satisfied that the Council's concerns about the viability of the development are genuine.
Yes, it may be that that's the best example. But this comes in at the end of the tribunal's reasoning, which, as I've sought to show the court, is addressed to questions of substance, judgment forming, the tribunal forming its own judgment about whether the concerns are real or not real. Put it this way, if the concerns were unreal, then the covenants must have been obsolete.
I'm sorry, could you say that again?
If the concerns were unreal, if they were lacking in substantiality, then and in that event, they must have been obsolete. It's intrinsic to the tribunal's conclusion, which is unchallenged under ground A, that the narrative I showed you in paragraph 42 embraces an independent evaluation of the question of whether the council's concerns were fanciful, rooted in reality or not. Because if they weren't rooted in reality, then in truth the covenants were obsolete on the tribunal's own reasoning. So my submissions drawing the points I sought to make together on that decision letter or decision judgment are first that there's no sign that the tribunal directed itself incorrectly in law. Secondly, in particular, it directed itself correctly about the Stockport principle. Thirdly, it held correctly that the Stockport principle was not engaged for the simple reason that the benefit secured by our covenants is a result of complying with them, not discharging them. And fourthly, I respectfully say that overall the upper tribunal's evaluation is not only sufficient, applying the forgiving approach of Lord Justice Carnworth in Shepherd and Turner, it's exemplary, as you would expect. So I turn then to the second limb, if I can put it that way. Paragraph 27, subparagraph 2 of my learned friend's skeleton argument, and then paragraphs 45 to 51. At least in writing, although less so orally, a significant feature of the appellant's case is the theory that the practical benefit that my client relies on is the protection of a negotiating position in relation to the potential new lease. And I am, as I've indicated, perfectly willing to assume that if that were our reason for resisting, it would offend the Stockport principle. But that is to mischaracterise our position. I've shown the tribunal the critical evaluation in paragraph 42 of the upper tribunal's decision, but beyond that, I would like to show the court some material that cements the point. First, and this is a sort of heading point, is the issues were argued. And this is clear from our skeleton argument in front of the upper tribunal, which is in the supplemental bundle. I'd like to call attention to page 92 in the bundle, paragraphs 11 to 12. In this case, the control that can still be exercised by the respondent over plot G as a result of the continued existence of the covenants is essential. Submissions made with the Stockport point fully in mind. For example, it's difficult to see how clause 2.2 could be used properly where there's a clear benefit to the respondent to ensure that the gas and electric mains and public sewers are not damaged by the building on plot G. And paragraph 12, what the applicant is doing by this blanket application is to denude the respondent of any ability to control what is happening on plot G. And in paragraph 16, addressing one by one the BAS questions, reasonableness and objective test, planning permission usually required, and then 5 lines down, does the relationship have the sentence beginning nonetheless? Nonetheless, it's clear that the applicant considers the building out of development is so obviously reasonable that this question should be answered resoundingly in the affirmative. However, when considering reasonableness, the tribunal
No, I'm
must...
sorry, I'm lost.
Page 93, paragraph 15.
Thank you.
I took it up 5 lines into the paragraph with the word
You ran over the BAS principles at 14, didn't you?
Yes.
Yeah. And
Your
so,
enthusiasm to get to 15.
nonetheless, I've got that, I'm sorry.
But there they are. If you want a convenient summary of them, that's where they are. Paragraph. That's the list. Yeah. And so, but yes, that's right. So the way it was addressed to the upper tribunal was through the perspective of this Caledonian case. But the point at which the tribunal rejected reliance on Caledonia, it rejected the argument that because the works were impractical, that meant that they weren't reasonable. But nevertheless, the point of substance is crystal clear, and it's developed in paragraph 16 to 17. The court may have glanced at these because they are highlighted, but can I emphasise paragraph 17? As to the issue of practicability, even if the applicant could fund the proposed development build itself, it would not be viable. And then in the last sentence, this would then leave potentially an incomplete development in an important and strategic part of the Great Jackson Street development framework. Perfectly permissible for the upper tribunal to take into account the practicability of the development. Paragraph 18 repeats the point. The leadership have towards the end of the 4th line the very real questions over the practicability mean that the restrictions complained of provide a tangible benefit. And then I've written with underlining in my note paragraph 30, so I better ask the court if it would mind to read that as well. Page 97. It's difficult to see, this is under the heading discretion, it's difficult to see how the tribunal could modify the covenants so as to enable the development to proceed. Accordingly, the covenants would all need to be discharged. This would be such a gross distortion of the respondent's proprietary rights, and that it would deny the respondent any practical control of the applicant's activities on plot G. It would amount to a complete variation of the lease terms. To exercise the jurisdiction that way can't have been what Parliament intended, and so on. So the topic was fairly and squarely before the tribunal. My next point is that as well as being argued by my client, there was no objection to my client putting its case in that way. In particular, the applicant did not object on the basis that my client's argument went outside the pleading. So, strictly speaking, it's irrelevant to consider the pleadings because obviously the tribunal cannot have committed an error of law in allowing the case to be advanced in this way without an objection having been made to it. It's only if it had made a ruling on an objection that an arguable question of law could have arisen. It wasn't asked to consider the point. No question of law rises. But I say that protectively because, in fact, when one examines the pleadings, it is clear that the council put this issue fairly in play. You were shown, I think, one paragraph from the respondent's statement of case in the upper tribunal. I think it may have been paragraph 14.2. But the court will also have in mind, perhaps, at page 53 in the supplementary bundle, for example, paragraph 14.3, referred that you've always been ready, willing and able to negotiate in order to achieve an acceptable outcome. It's referred that it's the respondent who refused to negotiate on a meaningful basis. So there's an intractable argy-bargy about who's to blame. It's impossible for anyone to try to resolve that. Who's going to adjudicate that question? Paragraph 14.4 at all material times, the respondent's been ready and willing to grant consent, provided that corresponding protections provided to the respondent in relation to, amongst other things, the failure or inability of the applicant to complete the said development at all or within a reasonable time. The applicant has rejected the terms proposed by the respondent and has failed and or refused to provide any alternative scheme for the respondent to consider. So if we assume for a moment that my learned friend's theory about Section 84 is correct, and there was some burden on us to say, what are the conditions that would meet our concerns? We've done it. We've said they can't be met. There are no conditions that can meet our concerns. But if you have some, appellant, show us what they are. But that's actually not the meat of it. Because the meat of it is where my client pleaded to the question of what are the practical benefits secured by the covenant. And that's done in paragraph 33, especially 33.1. And again, as you can see, these are not linked to securing a particular terms of a new lease. Paragraph 2, Roman 2, for example, page 57. The covenants secure very real practical benefits to substantial value parties. They enable the respondent to control the defendant. Responsibility to ensure that at the gateway to the City of Manchester, any permitted development is carried out to its practical completion. The applicant is a special purpose vehicle with no previous track record of carrying out a development. The accounts show a dormant company with a net asset value of £1. Notwithstanding the applicant's connection to other companies which hold significant assets, there's a very real risk that the applicant may fail or be unable to complete the development referred to in the planning application within a reasonable time. Or we don't need to take up more time on that because it's now admitted by the appellant in its skeleton argument, where it relies on the risk there described as one that has real substance. Even after spending £250 million, there is a risk of incompletion. In the event that the applicant does fail or is unable to complete the development, the consequences for the respondent and potential reputation damage to the City of Manchester are considerable. Well, that's an understatement. The respondent is and has at all material times been prepared to consent to the development referred to in the planning application on terms. The applicant has rejected these terms. Now, as I said earlier, for the applicant to have interpreted that as being my client saying, we want these covenants because they secure us a negotiating position, is that mixture of wishful thinking and Nelsonian blindness. We have volunteered a way out of the practical problem that presents itself. The fact that we have offered a solution doesn't mean that the problem isn't real. Doesn't make the problem any less real or substantial until it has been made to go away. And I'm sorry to have taken your ladyship through the weeds like that, but it's necessary to understand what the issues were in order to understand the reference my learned friend made to the request for further information. You've now seen what the issues were in the pleadings, and we can now understand the question that was being asked at page 61. Actually, we have to go to page 60. Question 1. The question had two features to call to the court's attention. The question was about what are the mechanisms you're seeking to ensure that, on your case, you're protected in the event that the applicant failed or was unable to complete the proposed development. 2 points to make about that, please. First, that's not a request for particulars of the practical benefits that you say are secured by the covenants. There's no request for further and better particulars of paragraph 33 of our statement of case. This is about the machinery we say would fix the problem. And the second point to note is that it's a request for details of the mechanisms on your case. I mean, it's one of those idle requests, frankly. They knew what the protections were because they're what we'd been negotiating about for months. What they didn't ask was, please assume that despite your objection, the upper tribunal in principle thinks that it ought to modify the covenants to enable the development to proceed subject to conditions. In that event, what conditions, if any, would you propose? That question was not asked. It wasn't asked there, and it wasn't asked in question 2 either, or elsewhere in this request. Despite not having been asked the question, at page 64, answer 2B, Ladyship will note that my client said this, amongst other things, is referring to protection afforded to the respondent lessor in the event that the applicant is in breach of its obligations under the terms of any release granted. The principal concern of the respondent lessor relates to the applicant's failure or inability to complete the development at all or within a reasonable time. Now, if that, combined with everything else, was not enough to alert the applicant to the need to formulate conditions to show how the council's concerns could be overcome if it had to do its development in 60 years, then there was nothing that would alert it to do that. It should have done so in its statement of case. The applicant should have done so in its statement of case. There's no hint of it. In fact, the statement of case is one of the loftiest documents I've ever seen. It just takes the position that the council's response is misconceived. The applicant did not apply to amend even after it had had our statement of case. It didn't at that juncture say, OK, the council has practical concerns, but we can meet them. This, that, or the other condition will meet them. Neither did it apply to amend after it had had answers to the questions it had asked. And when I say apply to amend, I'm not taking a formal point. My client couldn't care less whether it was a formal amendment or not. The point of substance is the applicant did not take the opportunity to formulate the conditions which it had to satisfy the tribunal would have overcome the council's concerns despite there not being a new lease. So the attempt to cast the blame for this onto my client is really, it's a bit rich. Now, instead of dealing with any of that at the hearing, the applicant maintained the position that our objections were legally irrelevant. The references in the applicant's skeleton argument before the upper tribunal are in the supplementary bundle starting at page 69, paragraph 5, paragraphs 21 to 23, 24 and 26.
So you give those paragraphs again?
5, 21 to 23, 24 and 26.
Thank you.
And I have shown the court the relevant bits of our skeleton argument, so I needn't refer to those again. I've then shown the tribunal, the court, how the tribunal resolved those issues, and I've made my submissions about that. So what does this survey I've just taken the court through, this material, add to the case? It shows that this case, on the ground, was conducted in the way almost all these cases are conducted. The expectation was that the applicant, if it wanted to put forward conditions, would do so. It had the opportunity to do so. And it didn't take up that opportunity, despite the plenitude of occasions when it could have done so. And it gets worse. This actually is the clincher. As Mr. Jordan showed you just after he came back from lunch, his client left it until a week before the hearing to come up with proposed modifications. They weren't handed to the tribunal until opening. And no submissions were made about them until closing. And then see what happened when Mr. Hutchings did make submissions about them. The relevant extract, the transcript, is in the bundle. It starts at page 173 towards the foot of the page. And then at page 174, in fairness to Mr. Hutchings, it does make a sort of grudging acknowledgement that it's all a bit late. It's headed "Agreed Appellant's Proposed Modifications," because it's not agreed, and to be fair, the respondents only saw the wording last week, and we're all right, yes, and we've not had a response, which I'm not obviously criticising. So this is not agreed wording subject to modification. I don't think I need to take you through each one, but you can see the way we structured it. And then the tribunal and Mr. Hutchings engage on a dialogue about, well, how do these measures actually protect the council's concerns? And you can see that it falls apart. By page 176, just below letter B, Judge McCreath is saying, what? So you'd have your cake, eat cake, of cake going on. Well, you'd have your building which is not complete. You'd be in breach of covenant but couldn't be forfeited. So you'd then be able to take as long as you want to complete it. Well, I'm not sure that's right. I think it would lapse, it would fall. I think if you want to, the tribunal then makes the point this isn't coherent. I think probably if you want us to consider that, and if you put it in, and Mr. Hutchings leaps at the opportunity, can I do that, in writing, and we can consider it. This has only been done last week, says Mr. Hutchings apologetically. Yes, says Judge McCreath, and my apologies. I see the points that are being raised, and thank you for pointing those out. Yes, we will do that. They did not do that. That is an admission that there is no form of condition acceptable to the appellant that would meet my client's concerns.
Sorry, I'm being a bit slow. So the point that's being made is, if you simply modify the covenants to allow it to take place, they could spend 250 million, and then they could run out of money, and then it would just be left unfinished, uncompleted, and you would have to wait 60 years before you could do anything about it, because you couldn't forfeit?
No, because the form of wording that had been produced would have postponed, or let me put it this way. The applicant had not satisfied the tribunal that the form of wording it postponed would have enabled us to forfeit in that event.
Because all it does is it modifies the covenant by permitting them to do something. It doesn't oblige them to do anything.
Exactly. It wouldn't have been... You can imagine the beginning of a framework that could meet some of the points. You could imagine...
You don't need a new lease. I mean,
Yeah,
you have two objections. One is, we're not satisfied actually doing it in 60 years is viable. It just financially doesn't stack up. But that, in a way, that's their problem. If they think they can make it work with the income strip and so on, and they can satisfy you can do that. That could deal with that problem. But you have another concern, which is that they could start it, they could spend a lot of money on it, and they could build the concrete shell and then run out of money.
Yeah, and the only way to deal with that, as your logic points out, whether it's a long lease or a short lease, the only way to deal with that ultimately, whether you call it a forfeiture provision or not, it's something that has the same effect as a forfeiture.
But you don't need a long lease for that.
No.
You don't need 250 years. All you need is a covenant in this lease which says that we will start it by X date and we'll finish it by Y date, and if not, it's a breach of covenant for which we can then forfeit.
Which is but the problem is, a covenant under 1C can only be imposed with the applicant's consent.
And they're not willing to consent.
They're not. That is the point. They are not willing to consent. Mr. Jordan was at great pains to emphasise that the negotiations have broken down. He admitted that the reason the negotiations have broken down is because his client has blanked, completely brick wall any possibility of forfeiture for the reason he gave. He doesn't want to see a situation emerging in which he's sunk £250 million, and as he sees it, the council walks away with the benefit of that. So that there is not a way, given the applicant's refusal to accept that kind of machinery, there is not a way to modify the covenants in a way that protects the council's concern under that completely pragmatic limb of its objections. It would take the applicant's consent, which it has doggedly refused, explicitly refused, in front of all judges on this bench, in open court. So then I turn to so far as it's really a separate point, but I do maintain, I do somewhat bridle at the introduction into this appeal of paragraph of subsection 1c, as if it ought materially to influence the structured approach to questions arising under subsection AA in the way that would be implied by my learned friend. Because if he's right, its effect is to create an evidential burden on the respondent to turn its mind to what kind of condition might meet our concerns. Potentially call evidence to address that and fight against itself. Because our case is we don't think there is one. And we might be wrong about that, for the reason Lord Justice Nugee has given. It may be that the concern of viability could be separated out from the concerns about completion. But that in turn comes back to what the applicant is willing to consent to. It's no good having an academic argument about this. On the facts of this case, everybody knew that that kind of protection was never going to be available because of the applicant's articulated position. But if you do indulge in that theoretical exercise, you see immediately the problem. It creates an evidential burden for the respondent, which it would have needed notice of. We didn't have that notice. And so it's not the sort of point that can fairly be taken in this court. But I have also, I admit, addressed the court on the merits. But if I'm wrong on the merits, the consequence is that my client will have been deprived of the opportunity to address itself fully to the question of, well, do we really have to grapple with this? And so if we're in that territory, I'd invite you for that reason not to allow the point to be taken. But if really we have to have the point taken, inevitably in that event, unfortunately, the thing has to go back. It has to be remitted. There'd be no alternative. And that, I suggest, would be highly unfortunate. I asked the court to bear this in mind. There's no limit on the number of applications under Section 84 an applicant can make. Of course, if there's no change in circumstances, then I suppose a new application might be vulnerable to being dealt with peremptorily in the upper tribunal. But if circumstances are said to have changed, there's no limit on the number of applications that can be made. The better course would be to dismiss the appeal. Allow the applicant to take stock. I was then going to yield to, if I may, to Miss Tithcott to address the court on the question that arises on our respondent's notice about compensation.
My lady, my lords, I deal with the matter that is at paragraph 2 of the respondent's notice, which is in the core bundle at page 56. And it is effectively inviting your ladyship and your lordships to approve the decision of the other tribunal on additional grounds, namely that they should have held that that money would not be an adequate compensation. Now, you will have seen from the discussion in relation to subsection 84(1) capital A, which is in the authorities bundle at paragraph 9, that if there is a practical benefit to be obtained from the covenant, then it can only be modified or discharged if money would be an adequate compensation. Now, this matter was dealt with in the council's skeleton argument before the upper tribunal, starting basically at paragraph 24, because it refers to the rebus principle, which my learned friend, Mr. Morshead, King's Counsel, has referred you to, and that is at page 96 in the supplemental bundle. And it's important, and I respectfully submit, for you to be cognizant of what was actually being put in respect of the council's position on that occasion, because again, with respect to my learned friends, Mr. Jordan, King's Counsel, and Mr. Dre, I submit that they have mischaracterised the council's position, because they're basically saying, well, they've pretty much opened the door to the payment of compensation. Well, that wasn't the case at all, because if one looks at paragraph 24, the references to 6 and 7 there are the references to principles 6 and 7 in the BAS checklist, and that's at paragraph 14. And because of the way in which the respondent's case was presented, it was submitted that as the applicant couldn't satisfy the tribunal that the covenants provided practical benefit of substantial advantage, then question 6, which is whether money would be an adequate compensation, fell away and did not need to be dealt with. And therefore, as it's pointed out in the appeal skeleton argument, the tribunal didn't deal with the issue either. But it can be quite clearly seen here that there is a clear reference to the decision of the Court of Appeal in Re Zenios, which is in the authorities bundle at page 391. That was a case where the objector was the Hampstead Garden Suburb Trust Limited, and the applicant wanted to build a first floor extension over the garage, and the objection was effectively this would be incompatible with the scheme for the area and the neighbourhood. And the passage I specifically refer to, my lady, my lord, is at paragraph 37, which is at page
404.
404, yes. And that is, I submit, really all that needs to be said in this regard. Because in this matter, Lord Justice Laws has accepted that the objector effectively holds the same status as the council, being a guardian of the public interest. And he says, I would also hold that on the true construction of section 84(1)(a), the reference to the circumstance that money might not be an adequate compensation for any loss or disadvantage is simply a condition for the satisfaction of section 84(1)(a), so that in this case that condition is not met, since the damage to the public interest represented by the trust could not be sensibly compensated by money. And that was the position that was taken by the council in front of the upper tribunal and has never changed. The upper tribunal accepted this construction at paragraph 13, and with respect not assisted by Ms Foster's reference in the stock report. Loss of an amenity such as a view or
Sorry,
a vista.
this is paragraph 13 of...
37.
37.
We're back at 37.
Yes.
Sorry. I'm so sorry. I was there and then I moved away. Yes, 37.
Just the very final sentence.
Yes.
Loss of an amenity such as a view or a vista may perhaps be compensatable in money, where the loss is that of an individual. It is quite another thing to postulate an award of compensation to a representative body guarding the public interest, as I have held the trust may properly be described. And that, I respectfully submit, is the position in relation to compensation. because not only was there no evidence that the applicants had actually satisfied the 4 sections set out in paragraph 2 of the respondent's notice, they couldn't satisfy the tribunal in any event because they didn't need any evidence that money would be an adequate compensation to any modification of those covenants. The respondent's appeal skeleton argument deals with this matter relatively briefly at paragraphs 57 to 60, which is at pages 81 to 82 in the core bundle. I won't take you to those because I know that you've read it. The issue of compensation wasn't mentioned at all in the appellant's appeal skeleton, but it was dealt with in their supplemental skeleton argument at paragraphs 46 to 55, which that starts at page 104 of the core bundle. And I've already referred you to paragraph 47, which I say actually mischaracterises the council's position. When one considers the way in which the case was put to the upper tribunal, the issue of compensation only arose when if it came to the position where the tribunal was satisfied that the conditions had been met by the applicant. Now, therefore, to a certain extent, if that's the case, there's going to be an attempt, I submit, that you're going to try and obtain a money compensation package in that context. But that was the only way in which the matter was pursued and presented to the upper tribunal. It wasn't effectively saying, well, if you pay us this, then we will be happy to do it. The principal and only real way in which the council was presenting the case was, you have to satisfy the tribunal because we are not satisfied that you have engaged the jurisdiction under paragraphs AA, and therefore we have to go on to consider this situation. And so in that context, my lady and my lords, the situation is quite clear, I submit, that there is no money that could compensate the council. Therefore, the double-limbed, or the 2 conditions set out in section 84(1)(a) cannot be met, and therefore this application cannot, or this appeal cannot succeed. The final point to make in this regard is in relation to the fact that there was the application proceeded on the basis of obsolescence ground A, double A, and then ground C, no injury. There's been no appeal against no injury either. The upper tribunal clearly stated that there was a benefit, a practical advantage. It was to control the way in which the development was carried out. It's set out in the paragraph 60 of the respondent's skeleton argument for the appeal, which is at page, if you need the reference, is at page 82 of the core bundle. And it refers effectively to the tribunal decision at paragraph 61, which is in core bundle page 125, which my learned friend Mr. Morshead Kingston has just referred you to. So what the tribunal said, that it made it clear that the injury that the respondent would suffer relates to the loss of practical control. That means there was an injury. That's inconsistent with the case saying there was no injury, and there is no appeal against that element of the decision. Now, unless I can assist you further, those are my submissions.
No, thank you very much.
I'm grateful. Can I then take up the other limb of our respondent's notice, which is the causation point? I've gone at great length in writing into this. So I hope that means I can abbreviate my oral submissions, for the additional reason that I very much hope we're not going to have to get into this territory. The point is actually a pretty short one. It's one of statutory interpretation. Where the Act asks you the tribunal to consider whether one thing impedes another, it's asking a causation question. And in many cases, it will be self-answering to an expert tribunal. Let me give you one example where I think one of the cases I'm going to show you went too far. One of the cases I rely on went too far, so I say this against myself. Let me give the example of my clients, for example. Suppose my clients didn't have the objections they put forward. They had a different objection. Suppose it was, look, this development will never happen because you need to negotiate a right of way over somebody else's land over there. My suggestion is that in most cases the tribunal will just give no weight to that as an objection because it knows, it's a specialist tribunal, it knows that in the real world it doesn't matter that at the moment the neighbour says you can't have a right of way. The neighbour might move on, move away. The neighbour might die. The children might be more interested in the millions of pounds unlocked by granting a right of access than in preserving the view. So the tribunal, as a specialist tribunal, can be trusted to separate that kind of question from questions that are actually insurmountable. But it does have to address its mind to the question where it's raised as an issue. And there may be a small residual class of case where the problem is literally insurmountable. If there is never a universe in which what impedes the development is these restrictive covenants, if that can never happen, it's a high threshold, but if that can never happen, the causation question has to be answered negatively. It has to be. And my criticism of the upper tribunal is that the issue having been raised on the pleadings, distinctly raised, it should have addressed that causation question.
Was it pursued throughout the hearing?
It was pursued through reference to the case of Caledonian and the Scottish cases, where the same point is made, but they use a different concept. They say that where the use is impractical, it's unreasonable. But it's the same point of
So do we see it clearly set out in the skeletons and in closing exhibitions and in oral argument?
Certainly in the skeleton argument, I believe the oral argument. If the relevant extracts of the transcript are in the bundle, I'll have to take instructions about them. But certainly in the skeleton argument, I in fact referred to the relevant passages. They're I think some of the highlighted passages, but I can show you Lordship those now in the supplementary bundle at starting at paragraph 15.1 on page 93 in the supplementary bundle.
Sorry, page 93 of the supplementary bundle, and then
Paragraph starting at 15.1.
15.1, thank you.
It's a reference to Caledonian.
So we're looking, I'm being too simple-minded. I'm looking for words equivalent to causation.
No, I've accepted that. The way the point was put was, in my submission, it was correct by reference to the authorities. My suggestion is that when we look at the authorities, which I'm about to do, we'll find that actually, although they have used this language of saying that an impractical use is unreasonable, what they are describing is a causation question. And that is the question of substance that needs to be grappled with and needed to be grappled with. But I'm accepting that it was what was not argued in front of the upper tribunal was expressed in the way I put it, causation. I'm not suggesting it was put that way.
Can I just unpick this causation question a bit? Statutory wording is, do the covenants unmodified impede a reasonable user? My understanding of what you said before is impede doesn't necessarily mean stop completely, but includes puts an obstacle in the way.
Yeah.
Well, when you have a proposed development, there may be all sorts of things which need to be done before you can actually carry out a development, you may need to acquire legal interests, like your right of way. You may need to get planning permission, you may need to have finance, you may need to have all sorts of things lined up, you may need to satisfy English heritage because it's conservation area, all sorts of things.
Yeah.
One of the things may be you may need to get round a restrictive covenant which on its face prevents you from doing it at all. Now why, when you're asking the question, is the restrictive covenant an obstacle to the development, do you have to answer the question, is it the only obstacle to development? Because if I get rid of that one, then I'll be able to do it. Well, that doesn't seem to me necessarily something you have to answer at all.
That's very much the reasoning that the Tribunal adopted in that O'Byrne decision. And that, so I'm accepting that your Lordships, as a statement of how in the overwhelming majority of cases the Tribunal ought to approach this kind of question, your Lordship's approach is absolutely correct. I was going to use the word adequate, except that sounds rude. But it is subject to the qualification.
But then
There might be.
There might be a case where it's so impossible to carry it out, it doesn't matter what the covenant says.
Yes.
But the covenant still stops you from doing it. I mean, that's my, just a matter of language of the statute. The fact that you can't do it because you're not going to get planning permission, which was the Scottish case, doesn't mean that the covenant isn't an obstacle. The covenant's still an obstacle. Whether or not, if you clear that obstacle out of the way, there'll be something else which is insuperable. That's the difficulty I have with this one. I mean, we don't need to decide if a Scottish cases are right or not, because they're Scottish cases. But it's not obvious to me that asking the question whether a covenant impedes a development asks any question at all about how feasible or possible or practicable or legally allowable the development would be if you got rid of that obstacle. I don't see why it doesn't just ask the question, is this an obstacle?
I'm not in a position to say to your Lordship that that interpretation is impossible. I don't say that. I go further. I accept that your Lordship's preferred interpretation it sits very comfortably with the decision of the Tribunal in that O'Byrne case. But I do maintain, respectfully, the submission, that what is posed is a causation question involving an assessment of fact. There has to be a universe. It has to, and in most cases there will be. There has to be a universe in which it is foreseeable that the covenant might, in fact, impede the user. I would test it this way, by reference to facts that are even more extreme than our own. Suppose the application that had come forward was to build some, I don't know what to say, a rocket launching site. Okay. It should be open to the Tribunal to say, no, we don't need to take up judicial time, judicial resources dealing with this. There is not a universe foreseeable as at today where that is ever going to happen. And rather than having to deploy the full ambit of tools and analysis under Section 84 to achieve that result, it should be possible to say simply, no, these covenants are not what impedes that end user in any universe that is foreseeable as of today's date. Now, if that's right in point of then I do suggest that it was incumbent on the Tribunal at least to address its mind to whether, on our case, that principle was engaged. Whereas we say, what's distinctive about this case is that if we're right about viability, it will never be the restrictive covenants that prevent completion of the development. It will be whatever covenants emerge.
But the Tribunal said, we don't really have the evidence to decide the question of viability, and we're not going to do so. So why is that not like your right-of-way case? There is suggested by one side, but denied by the other side, a practical obstacle. You say a 60-year development just doesn't make any financial sense. And they say, no, we can make it work. Tribunal says, we're not going to resolve that because we don't have the material to resolve it. Why is that not like saying, you need a right?
No, that would be, I accept that. I accept that if I'm stuck with the tribunal's evaluation of the viability evidence, game over. I accept that. Which is why I have also challenged the tribunal's assessment of the viability question.
Why do you have to talk about causation? Why isn't it just, I mean, this may be a stupid question, tell me if it is. Why isn't it just a question of the first BAS question? Is the proposed user reasonable?
I suppose it's because if I go back to my absurd sort of rocket ship...
Well, then that's obviously unreasonable, isn't it?
Well, I'm not...
That is the theme part.
But some intermediate example where the use can be seen as, in itself, not unreasonable. The problem is it can't happen. It just can't happen in a foreseeable universe. That's not so much an issue with the use...
So where does this fit in the BAS? This is an extra question. No, wasn't asked in BAS then, is it?
I think that's right. I think it's within the... It's probably within the questions, but it isn't spelled out separately. I agree with you.
If it's within the questions, then it's capable of being answered within the questions.
Well, it may be for that reason that the way it's put, or it may be for a related reason. I don't know that they have exactly the rebas checklist in Scotland, but it may be for that kind of reason that it has the analysis has been put in terms of saying that an impractical user is not reasonable.
Can you think of an example of a case where the reasonable question one in BAS would be passed, but your hidden subsidiary question
Ours is
not?
the example. Ours is the example.
Okay.
Where you have a use which everybody agrees is not only reasonable but desirable. The problem is that, again, assuming I'm allowed to go behind the tribunal's finding on viability, it can't happen. There isn't a universe in which that can happen under the existing lease. It just can't happen. What it might happen under is under a new lease, but then it won't be these restrictive covenants that are an issue.
Has this all been addressed in questions on reasonable use in other cases?
Not that I've been able to find beyond these cases that I've the Scottish cases that I've shown you. But that brings me to the question of I've accepted, in answer to my Lord Justice Nugee's question, that this argument doesn't go anywhere. Unless I can...
Good decision to make it 10 to 4.
Unless I can also...
Concession.
Well, I'm glad that something I've said is helpful. But in case... I make the submission, in case I'm also able to, is I would urge the court to persuade you that the tribunal made a mistake in its approach to this question of viability.
Where do they deal with it?
Paragraphs 28 through to 30.
This is the bit where you said you were going to... You flagged up you weren't going to agree with all of it, didn't you?
Yes.
When you mentioned
It's 28 to 30, and then exactly they come back to it at 49.
Not prepared to form a judgment.
Yes, but can I invite the court also to go back to paragraphs 28 through to 30 on page 117? Where there's a criticism of Mr. Rose's evidence. Including on viability.
Where in particular do you say on viability?
It wasn't. Does your lordship have the last 3 lines? Well, it's really. The witness said the witness's explanation for how it could be made viable was to say, well, actually, we can do lots of short-term sublettings ourselves. And the tribunal said, well, that's just an improvised response.
Well, paragraph 30 is where they...
That's right, and then they come back to it. We're left with 2 concerning impressions.
On the hoof.
On the hoof, and its real objective is its negotiating gambit. Now, my point is a simple one. The question of viability was in issue, distinctly in issue. I've shown the court the bits of our statement of case which put it in issue. It was therefore incumbent on the applicant to prove viability. And it didn't. It's not a case where the tribunal was justified in saying we decline to take a view.
Why does it have to prove viability? Well, the question is, do the covenants impede a reasonable use? Then there are other questions, but that's the question you're on at the moment. Why is it not enough to say, here's a use, this is a reasonable use, covenants stop us from doing it, therefore we pass those questions. And we don't have to show we can make it work. It's not one of the statutory questions.
Well, it's because the case that they knew they had to meet went as far as saying that one of the reasons why this is a particular risk, why the risk of non-completion is a particular risk, is the absence of viability.
Yes, but that's a slightly different question, which is whether it secures a practical benefit. Practical advantage.
It's certainly relevant to that question. It is. But where the facts are as extreme as this case, that's my point. It goes further than that. It is capable of showing that there is not a foreseeable universe in which this development can happen.
Well, I can understand that if you called evidence which was accepted by the tribunal, that no possible development could take place of this type and be financially viable, and the tribunal has accepted that, then you might have a case for saying that in itself shows that it's not the covenants which is impeding a reasonable user because there isn't one. But you didn't.
And hence 49, paragraph 49.
And they end up by saying, well, we weren't very impressed with the applicant's evidence, and we're not even sure they've really worked out how it's going to work. But we're not going to reach a conclusion on it, which...
So that's my criticism.
Well, speaking for myself, I don't see what's wrong with the tribunal being presented with some very late and half-considered evidence, saying, well, we don't know what the answer is. We're not going to base our decision on something where the evidence is so...
Well, that I can understand. I can understand the disinclination, or let me put it the other way around, the inclination, which is a proper judicial inclination to decide the smallest possible number of issues. I can understand that.
One which I think we all have sympathy with.
Yes, well, I especially at 10 to 4, so I won't take up too much more. You have my submissions on the point.
Thank you.
I don't think I'm going to improve them with repetition. That takes me to discretion, which is the last of the topics. I think I am going to finish by 4. The overarching point in relation to discretion is this, that we only reach discretion if the appeal would otherwise succeed. And, if that happens, it's because the tribunal really misdirected itself profoundly about the law. And that would strongly suggest that the whole of its exercise of its discretion was just on a wrong basis. It approached the exercise of its discretion on a wrong basis, informed by a misunderstanding of the law in earlier parts of its decision. It would not be safe under those circumstances to assume that the exercise of its discretion would be the same had it directed itself correctly.
So if you lose on jurisdiction?
If I lose on jurisdiction, it is as if there has been no exercise of discretion.
And then do you ask us to exercise it? Or
No, it has to go back. For the reason I've given, it would mean there has been no exercise of the discretion.
Well, we can, in appropriate cases, exercise. We've got all the powers of a lower tribunal.
Except that that is true, but it is a power to be exercised by way of review of a decision entrusted by Parliament to a specialist tribunal. And those are distinctive features of cases like this. It's not just a case where there are questions of fact to make. It's not just a case where, put it this way, with respect, what Parliament is interested in is not the Court of Appeal's assessment. It's not the Court of Appeal's exercise of discretion that Parliament is interested in. It's given that job to the upper tribunal. What it's given you is a power to review that jurisdiction on questions of law on points.
This happens in quite a lot of areas of law. It adds tremendously to the delays and costs.
It can add to delay and cost. It
will
can.
It will add to delay and costs.
It can, but it can serve the interests of justice, especially in a case like this, where the reasons why the court would be allowing the appeal include reasons that might well have affected how the case was conducted below and might well have affected the kind of evidence that the...
Well, I was going to say, presumably another point is it all turn on evidence, evaluation of evidence, and perhaps things have moved on.
Things might have moved on, and it would be, I respectfully urge the court to be very wary about considering that it's in a position properly to exercise the jurisdiction that's been entrusted to the specialist tribunal without hearing updated evidence, without any of the benefits that are available to the tribunal after a fresh hearing, that you would be denying yourselves. I urge you very strongly not to do that. So far as concerns the reasons that the tribunal gave itself when indicating as a fallback why it would anyway have refused to exercise its discretion in favour of the applicant, I don't accept that there was no evidential basis for the tribunal's conclusion about the negotiations and the potential for negotiations to become unlocked. I don't accept there's no evidential basis for that. And I've referred you to paragraphs 27 through to 30 of the tribunal's decision. It was open to the tribunal to infer that the posture adopted by this applicant was just a negotiating ploy. This litigation, it's playing hardball. It was a perfectly legitimate inference for the tribunal to adopt, that there is nothing set in stone about the applicant's negotiating position. It is just that. He's playing a very tough game, but it is just a negotiating position. So I don't accept there was no evidence to support the tribunal's assessment on that front. Equally, I don't accept that it's legally irrelevant for the tribunal to have been wary about making a decision that would interfere with those commercial negotiations. Bearing in mind the point that Lord Justice Evely made in that case of
Gilbert.
Gilbert, yes. What the tribunal is vested with is a jurisdiction that interferes with private property rights. As I've emphasised, you might have thought otherwise from some of Mr. Jordan's submissions. His client has no right to a new lease. It has no expectation or right of a new lease beyond what it can negotiate. It has none at all. So to say that that puts my client in a ransom position is, so what? That is the position the applicant is in. It is in the position of supplicant. And the tribunal was right to be wary of taking a decision that might change that around. And instead of the applicant being the supplicant, suddenly a state of false equality has been achieved in the negotiations. Why? It's no part of the upper tribunal's business to confer a negotiating position, to improve a negotiating position on a disappointed applicant. The upper tribunal was fully entitled to take into account that consideration. I do not accept that it was irrelevant. So both the criticisms advanced by my learned friend as to why the tribunal erred in law, if and to the extent that it exercised discretion, I respectfully reject. So, unless I can help you further, I say that reluctantly. It implies I've said something that might help you, but unless I can help you further, that's all I have to say.
No, I think that the answer is thank you very much indeed. Mr. Jordan, how long will you be?
Just take a moment to review. I don't think I'll be more than. I don't think I'll be more than 15 minutes, and then Mr. Dre has to address compensation. I don't know how long.
My lady, 10, 15 minutes maximum from myself.
So, as long as everyone else is content and there are no issues at all, I think we should do both of those this afternoon.
Very good. Can I deal with the eyesore point first? The council's concern, and my Lord Justice Nugee said, well, really, would it be so much worse than having two redundant 1970s warehouses? My learned friend said, well, there's a control in the form of the repairing covenant. There's also a control in the case of the buildings being demolished, which my learned friend, more in skeleton arguments, but also briefly in his oral submissions, said was a serious concern. I can just show the court briefly a clause in the lease which we weren't seeking to modify. It's in the supplemental bundle at page 33. So there is a repairing covenant at subclause 4, and at subclause 6 there's a covenant to keep all parts of the said plot of land not covered by buildings and to keep the demised premises generally in proper and neat order and condition and properly to maintain, etc. So we can't just let the site become a wasteland that was suggested. That would be a breach of covenant for which the council would have all the usual remedies, including forfeiture. And there is, in addition, a standard Jervis and Harris clause at page 37, clause 18, which allows the council to serve notice requiring any, it's on page 38, to enter upon the demised premises to view the state and condition thereof, and to repair and make good with materials to be proved by the lessors all defects and wants of reparation which shall on any such inspection be discovered, for which the lessee is responsible under the provisions of this lease or otherwise. And then if the tenant still doesn't do that, the landlord can go in and do it and recover the cost from the tenant. So it's simply not right to say that this spectre of some horrendous feature appearing, either in the form of a wasteland or a building that the council has no remedies in respect of under the lease itself. In a way, the fundamental debate between the parties on this appeal is what the tribunal decided. My learned friend says what the tribunal decided is that the ability to prevent the horror of a cleared site instead of two redundant warehouses, or an unfinished set of blocks of flats instead of two warehouses, that was a substantial benefit. I say it's clear reading the decision as a whole, and in particular the parts I drew attention to, and perhaps most clearly the penultimate sentence of paragraph 60, that what the tribunal thought the practical benefit was enabling the council to insist on the development actually being carried out on terms it required. And if we're right about that, then the Stockport principle is directly engaged, and my learned friend doesn't contest the accuracy of that principle. If the tribunal decided what we submit they decided, then it seems to be common ground that that was an error of law. If the tribunal decided what my learned friend says it decided, then the position is obviously different. But in my submission, they never did that. There's not a hint anywhere in the decision that what they thought they were doing was balancing the risk. And my learned friend said it's a very real risk. I didn't say it was a very real risk. I said it was a risk. There is a possibility with any developer that circumstances beyond their control may cause serious problems with the progress of a development. It's not what you expect to happen. It's not what usually happens, but occasionally it does happen. So I do accept that there's a risk. There's no sign that the tribunal was trying to evaluate that risk and to compare it against leaving things as they were. What it was doing was saying the practical benefit for the council is being able to insist on the development going ahead, and this missing piece of the development jigsaw being put into place. My learned friend made a submission about a 1-year lease in which the tenant applies to the tribunal to modify the covenants to carry out an expensive and time-consuming development. Fanciful examples rarely help in the analysis of a statute, and that is a truly fanciful example. The tribunal said that issues of practicability would be dealt with under the tribunal's discretion, and any ridiculous application of that kind could be shortly disposed of by saying, well, yes, this development is one which it would not be a practical benefit to stop, but given the impossibility of carrying it out in the exercise of the tribunal's discretion, we refuse to grant the modification order. So that's how that sort of issue, were it ever to arise, very improbably would be dealt with. As to rebas and the conditions in rebas, it is a checklist that is often used by the tribunal. Could I just show the court briefly what was said about it in the Edgware Road case? Page 199 of the authorities bundle. This is Mr. McCrae, and at paragraph 111, he said in the third sentence, while rebas provides a convenient list of the issues which may arise on an application under 84(1)AA, it's not always necessary, in my view, to answer the questions in a strictly sequential manner or to address them all in every case. What is required is an assessment of the issues which arise in a particular application by reference to the relevant parts of the section, and then the consideration as to whether the tribunal should exercise its discretionary power. So rebas is nothing more than a commonly used checklist, but it doesn't take one any further forward than that. My learned friend said that this court shouldn't interfere with an evaluative decision of the tribunal where it reviewed the evidence and made an evaluative decision, and I don't quarrel with that at all. That isn't what I'm asking this court to do. I'm asking this court to say that the tribunal made an error of law in the interpretation of section 84(1)A. My learned friend also said he quarrelled with the distinction between jurisdiction and discretion, but that is built into the structure of section 84 itself. In particular, it's recognised in subsection 1B how the tribunal nearly always approaches the matter. First of all, it says, are one of the statutory grounds made out, or more than one? And then, if so, should the tribunal, in the exercise of its discretion, make the order modifying or discharging the covenant? And there's no reason to depart from that. They are quite... Obviously, a lot of the material may be relevant to both, but they are different issues. One is, can we do it? And the other is, should we do it? Paragraph 42 of the tribunal's decision received significant attention from my learned friend, so I need to go back to that. That's on page 121 of the core book. Page 120, apologies. One needs to put this in context. This is dealing with the argument that the user covenant was obsolete. That was the one that Mr. Hutchings focused on, as you can see from paragraph 36. Mr. Hutchings' main focus was on clause 2.8 of the lease, which restricts the use of the site. And then on page 120 at the top, paragraph 40, Mr. Hutchings submitted that the council was withholding consent simply to improve its bargaining position in negotiations for a re-gearing of the lease. And then he referred to Driscoll and Church commissioners. And if one looks about halfway down the page, halfway between the two hole punches, in the quotation from the judgment of Lord Justice Denning, does the court see the sentence beginning, if he uses it reasonably? if he uses it reasonably, not in his own selfish interest, but in the interest of the people of a neighbourhood generally, as for instance when he gives his consent for any reasonable change of use, then it will serve a useful purpose. So this is the question of whether a leasehold covenant is obsolete, and the answer is if the landlord is using it not in his own selfish interest, but in the interest of the people of a neighbourhood generally, then it will not be treated as obsolete. And that is what the Tribunal was addressing in paragraph 42. The Council's aim in the negotiations is not a purely commercial one. It has a legitimate strategic interest in continuing to influence the use of the land on the fringe of the city centre and secure its orderly and appropriate development. And there's no reason why its promotion and protection must end with planning. The leasehold covenants allow it a further opportunity to control the site. And then it said the evidence of Mr. Richard satisfies us that the Council wishes to ensure that the development takes place in the manner proposed by the applicant, subject to appropriate safeguards to ensure it's commenced in a timely fashion and not left incomplete. That objective, i.e. getting the building completed, as Mr. Richards wished, was plainly in the interests of the public of Manchester. Therefore, the covenant wasn't obsolete. The reason I didn't go to that is because in my submission it was saying absolutely the same thing that the Tribunal said in paragraphs 51, 52, 53 and 60. It wasn't saying anything different. It certainly doesn't add any force to my learned friend's submission, because it's quite clear that what the Tribunal was recognising was the wish that the Council ensures that development takes place in the manner proposed by the applicant. Nothing there to support my learned friend's submission that the practical benefit identified by the Tribunal was leaving two redundant 1970s warehouses standing in place. My learned friend says his client is in a ransom position because the lease is 60 years long. But that isn't the case. The ransom is provided by the user covenant in the lease. Every other covenant, insofar as it impedes an improvement, can be dealt with under section 19, subsection 2 of the 1927 Act, but not the user covenant. The user covenant gives the Council an absolute veto over the development being carried out under the existing lease. So even if all the Tribunal had done was to modify the user covenant so that it permitted the ultimate use of the building for residential purposes subject to the development being carried out, we would be in a significantly better position. We would still have to apply for the Council's consent to carry out the building works, but that consent couldn't be unreasonably withheld. My learned friend addressed my references to the fact that the Tribunal's findings on the evidence were that the Council's concerns were genuine and that the Council had a wish for things. And my learned friend said that's a new argument. It's not a new argument. It's me answering a contention in the respondent's skeleton argument at paragraph 6 that the Upper Tribunal made a finding that the Council's concerns were not only genuine but justified, and it didn't make that finding. That's all I was saying. And it's also wrong to say that if the Council's concerns were genuine, that would, if the Council's concerns were unreal, my learned friend said, the covenant would be obsolete. But the point that was being made in the passage of the decision I've just taken the court to is that the question is whether the landlord is seeking to use the covenant in a way it believes to be in the public interest. And the Tribunal said it was. It didn't go further and say the Council's fears are justified, and on the finding, we make a finding on the evidence that if this building is started, it won't be finished or anything like that. There was no findings of that kind. In relation to conditions, the court has now seen enough to see how this case was approached by both sides. We approached the case by saying the Council wants the new lease and it's just trying to extract money from us, which the Tribunal didn't agree with. And the Council said, under no circumstances can this development take place except under the new lease. So what the parties didn't do is address a situation where the Tribunal said, well, the ability to impede this development doesn't afford practical benefits, therefore we have power to modify, and we wish to consider whether it's appropriate for any conditions to be imposed. And it isn't right to say that subsection 1C requires the applicant to put forward conditions. That's not what it says, and that's not how it's applied in practice. It is open to the applicant to put forward conditions, it's open to the respondent to put forward conditions, and it's open to the Tribunal to say, we consider that conditions are appropriate, both under 1C and in the general exercise of its discretion. My learned friend says that if the court finds that there were errors of law, or an error of law, and that the tribunal did have jurisdiction, the case should be remitted. Our preference is for the court to do what was done in the Alexander Devine case and exercise the powers of the upper tribunal itself. If the court takes the view that the question of conditions ought to be addressed, then that could either be dealt with by the court or by remitting it to the tribunal to address that question. On the 2 points of discretion, I don't really want to add much to what I said in opening, except to say my learned friend didn't accept that there was any evidence, didn't accept my submission that there was no evidential basis for the finding on negotiations, but he didn't identify any evidence which could have led to the conclusion that the tribunal, by modifying the covenants, would have interfered in a negotiation. I'm going to now allow my learned friend Mr. Gray to address the court on compensation.
Lady, my lord,
Mr. Gray.
I'm going to respond, as has been indicated, to the compensation point and the submissions of Ms. Tiscott. Ms. Tiscott drew the court's attention to the Xenios case, and she placed particular reliance on the dicta of Lord Justice Laws in paragraph 37. I needn't take the court back there, but for your note, it was page 404, right at the end of the authorities bundle. In my submission, whilst I have no quarrel with that decision for itself in its own setting, it doesn't afford any support to the present case, for the facts are utterly distinct. Primarily, in that case, the Hampstead Garden Suburb Trust was a trust whose very function was to look after the amenity of the Hampstead Garden Suburb. And indeed, in paragraph 34 of the judgment of Lord Justice Laws, the trust's role was described as entailing a duty to do that. Now, in the present context, however, the question arises as to capacity and as to hats. And it's the appellant's case that, in the context of the enforcement of this particular covenant in the lease and the opposition to the Section 84 application, MCC, the Manchester City Council, is operating and not, as was the trust, as a body representing and guarding the public interest, but simply as a private landlord in its own private capacity. I seek to make good that point by reference to, I think, about three quick pieces of documentation in the bundle. The first is the lease itself, but that, of course, regulates and set up the parties' relations in the first place. The lease can be found at page 30 in the supplementary bundle. And what I draw from that is it's an entirely standard form instrument regulating proprietary interest between a landowner and the person to whom the grant will be made. The covenants with which this court has been concerned today, and which begin at page 32 at clause 2, are made between the parties in that capacity as lessee and as lessor. And then, most clearly, turning towards the back end of the lease, and at page 45, the court will then see clause 3, Roman 6, the first complete sub-clause on page 45, which provides that, for the avoidance of doubt, nothing in the lease shall affect the council's rights, powers, duties and obligations and the exercise of their functions as local planning authority or highway authority or any other capacity. I submit that that underscores the distinction in the hats that the are being worn, and shows that in the case of the lease and the covenants with which we're here concerned, the council is acting purely in a private capacity. And I then ask the court to turn to the upper tribunal's decision back in the core bundle, for there are 3 paragraphs in that which my submission confirm that that is the analysis which the tribunal itself adopted. And the first passage would be at page 123, paragraph 51 in the upper tribunal's decision. And it's some 5 lines down when addressing the question whether the restrictions secure practical benefits. The tribunal concludes, as planning authority, the council not only does not object in principle to the development occurring, it's positively and enthusiastically encouraged it. It puts that to one side, of course, because the objection arose, as the text continues, as landlord. It, that is to say, the council nevertheless seeks to include provisions within a new extended lease to which the applicant objects. So that is the distinction of role spelt out writ large, and it is entirely in line with other observations in paragraph 41. Ask the court to travel back to page 120, where the submission of Mr. Hutchins is recorded that the purpose of the covenants were to protect the reversionary interest of the council. And the tribunal says, we agree this was at least part of the purpose of the covenant, but nothing in the evidence suggested it was being used for any other different purpose. So the covenants are prayed and eyed and relied upon, and the objection to the application is founded simply on the protection of the reversionary interest of the council. There's a proprietary interest.
What about paragraph 42? Which we looked at a moment ago.
In relation to paragraph 42, in my submission, whilst it is, I acknowledge what is said there about an objective being in the interest of the public of Manchester, the point is that there is no duty on the council wearing its hat as private landlord to concern itself with the wider public considerations. It may choose to take those into account, but it is entirely distinct from the situation of the trust, which was under an obligation to look to the interest of those whom it represented. In the present case, if, for example, the local authority wished to, as private landowner, wished to release these covenants on payment of some compensation, a deal was struck, it would be entirely open for it to do so without any shackles as to its public law duties. It is acting simply in the exercise of its proprietary rights, and in my submission it has entire freedom as to how it behaves. And in my submission that is also consistent with the concluding remarks of the tribunal in paragraph 63, page 126, where the tribunal, concluding the question of their consideration of the discretion, say the tribunal should be slow to interfere with a local authority which seeks to use its private rights as landlord to promote its strategic development plan. Then going on to say, we see no reason why this will be liable to disrupt continuing negotiations between a local authority and a commercial developer, both of whom are well able to protect their interests. In my submission, this again feeds into the notion that the local authority in the present context is operating simply with a hat as a private landlord. And the last document I would take the court's, draw the court to on this point is in the supplementary bundle at page 289. And in my submission, this document shows that the local authority itself has drawn this very same distinction that I'm now advocating. Page 289, the court will find a letter from Manchester City Council of the 23rd of December last year. To explain, this arose in the context of the request for consent to undertake demolition of the warehouses at the site in order to implement the planning permission and to commence the material operation. That, as the court may be aware, has been objected to by the council, and there are in fact separate proceedings on foot in that regard.
So this is post the hearing before the upper tribunal?
It is, absolutely.
So, therefore, on what basis are we looking at it?
Well, it's because...
Is it new evidence?
In my submission, it's the expression from the council's own lips as of the points I've already made good, which are, and it's that I just refer the court to that final paragraph, the bottom paragraph on 289. They say that your letter doesn't recognise that our client wears several different hats. They are separate and distinct and not to be conflated. And in my submission, again, it is a recognition that the council is acting as a private body. My next submission is that if the development should be undertaken in part but not completed, and let's posit the most immediate bone of contention, which is that of demolition of the warehouses and clearance of the site, then if that would result in any loss to Manchester Council, in my submission, it is no more, no less than a loss of amenity. And the law is well versed in compensating parties for losses of amenity. It does it in the case, of course, of bodily injury and of damage to feelings, and it does it similarly in the context of property rights, whether they be, for example, a right to light which is infringed and an injunction is refused, but some damages are awarded to compensate for the prejudicial effect of the slightly reduced quantum of light, and it does it routinely in the Section 84 context. There is, by way of example, one authority in the bundle. It's the Coles case in the authorities bundle, and I can take the court, if I may, immediately to the relevant passages in that. It's at 160.
So 160, page 160.
160, yes. A successful application for modification of covenants, but I rely on it as merely an example, but a convenient one because we have it included for other purposes in the authorities, at paragraphs 46 and 47, which I invite the court to read, but my lady, I draw from that the fact that the tribunal, in this precise statutory context with which we're concerned ourselves, is perfectly able to award a financial sum by way of compensation for what is inherently and intrinsically an intangible loss. The fact that it can't be quantified, the fact that it doesn't even stand in a diminution in market value of a property, doesn't preclude an award being made to compensate a respondent objector in the event of a successful modification of the company. So there is nothing as a matter of principle which stands in the way of an award of compensation for non-monetary matters. And the final point I wish to put before the court is that actions and conduct speak, I admit, louder than words. And you've heard from the local authority that they say, well, we couldn't be compensated in money for the loss that might flow in the present case. But actually, the way this case presented itself paints a rather different picture. The first thing that happened, of course, was the making of the application, and then there was filed a notice of objection. In that, the respondent ticked a box saying that they wished to claim compensation in the event the application succeeded. That's not a document before the court, but I'm sure it's not controversial. The matters was then carried through into materials which are conveniently found in the supplemental bundle. Page 211. This is an open letter from the respondent.
I've lost track of time, but is that
this is my
before
fault.
the...
I'm sorry.
It's the 1st of December 2022.
Before, this is just shortly after the application has been made and the objection registered.
Okay.
But before the tribunal proceedings, which were in July of 2023.
Yes.
And I invite the court to look at the first paragraph on the next page, 212. So the council was quite clear it was going to be seeking compensation. In the interest of time, I'll just ask the court to note that at page 50 there's a correspondence from 6 days later to similar effect. Following through, the council adduced expert evidence from its valuer, Mr. Ward of Savills, and an extract from his report is to be found at page 144 in this bundle. And the compensation sought was summarised in the final paragraph on 144, paragraph 17.23, which has been highlighted. And the sum sought was some £2.5 million. And this was said to be what ought to be paid by way of compensation in the event that modification went through. And then the final document I need to take the court to is the respondent's trial skeleton argument. Mr. Tithcock took you to paragraph 24 of that. But I would invite the court to crawl further into it, into paragraphs 32 and 33, which are to be found at pages 97 and 98. My lady, what I invite the court to extract from that position and the earlier correspondence is that it sits ill for the respondent now to advance by way of an additional point in its respondent's notice a contention that it could not countenance a monetary award when its very position as foreshadowed before and during and throughout the tribunal proceedings was that it was quite capable of being compensated, and it sought a very significant sum to that in that respect. In my submission, therefore, there is no reason for upholding this additional ground of objection to the application, and the application, if you're persuaded by Mr. Jordan's arguments in relation to the substance of the appeal, should succeed without being stymied by the compensation ground of Section 84. unless I can assist the court further, those are my submissions on the compensation point.
Thank you very much indeed.
Lady, the one remaining point is the respondent's notice grounds 1 and 1A, I think they are, which my learned friend dealt with, the argument that the viability issue should have been decided by the tribunal against my client, and that on that basis, having found that the development wasn't viable, it should also have found either that it wasn't a reasonable use of the land or that the covenants weren't impeding the use because it wouldn't happen anyway. And I want to adopt, if I may, respectfully, the points made by my Lord Justice Nugee, which were put to my learned friend and which put very eloquently and clearly the points that I was going to make in response to that, and I don't wish to add anything to those.
Thank you, Mr. Jordan.
In response to the respondent's notice on compensation, I won't say anything on ground 1A point. Time is very pressing. I don't actually intend to take up any more of it. I'd invite the court, when evaluating the arguments you've heard from Mr. Dray, please to reread the way it was put in the skeleton argument on this point in the core bundle of pages 103 to 105, which no doubt shaped the way you were addressed by Ms. Tithcott in relation to these issues. The one point of law that got my ears a little bit alarmed was the suggestion that the council might have a free hand in the terms it reaches with this applicant. That's plainly wrong in point of law. This council is affected by section 123 of the Local Government Act 1972. It cannot dispose of or create an interest in land except for the best price reasonably obtainable. So I won't take
That's
that.
section 123, Local Government Act.
1972. Sorry.
Well, thank you very much, everyone, for your submissions and those behind you for the hard work that they've done in relation to this case. They were all extremely helpful. Thank you too for compressing them, perhaps. I hope you haven't compressed them in a way that you're not satisfied with. You have had full opportunity. But thank you for being succinct, because I think that is helpful overall. As you'll know, the way in which matters are dealt with in this court is that we will circulate a draft of our judgments as soon as we can, and that draft or drafts will be circulated to those whose email addresses have been provided, and we take the embargo in relation to that draft extremely seriously, so please do not extend that circle unless you have actually asked for permission to do so, if I put it that way. And thereafter, as you will also know, we are grateful for suggestions in relation to typographical errors and even our grammar, but not our reasoning. And so please, as you will know, don't try to re-argue your cases in any way. And also, once that process has taken place, we also hope that you will be able to agree an order in relation to consequential matters. If not, very short submissions, written submissions, should be submitted, and usually those are to be submitted at the same time as the corrections for the drafts, and by very short, we mean very short. And we'd be grateful for those, therefore, and that would be extremely helpful. And as you also know, those written submissions, if you cannot agree, will be considered and the matter will be dealt with on paper. So there will be no need for you to return here, because as you also know, these days, hand-down is electronic. Is there anything else?
May I cheekily ask for some guidance on the extent of the embargo? The way I've interpreted it is that it's so strict that the parties cannot, in the embargo period, even discuss between themselves what form of order is appropriate. Would your ladyship envisage lifting the embargo sufficiently to enable that practical step to be taken between the parties? Or do you require the embargo to be so strictly observed that even that should not be attempted.
Well, my understanding, and I will be put right by either of my colleagues if I am wrong, is that during that period, in order to be in a position to agree an order, it's essential that you speak about that with each other, because it's likely that you'll be asked to agree that order if you can, or to make your submissions in the same time sequence as looking at the errors that we have made. Is everyone content with that?
Yes, that's my understanding as well, although I can see on the wording of the embargo, it doesn't actually say you can talk to your opponent.
No, it doesn't.
But that is the usual practice, that you are encouraged to try and agree a draft order once you know what the result.
Well, I thought it was just worth obtaining a pre-permission rather than apologising later for some mistake.
Certainly for my part, I would urge you to do what you can to agree an order during that time span, and therefore you will need to speak to each other.
Yes, I was going to say, if that's a breach of the embargo, I've breached it
Many times.
dozens of times.
No, I've not fallen into that.
Always
anything
understood the
else?
embargo. Yes, may I ask for permission for Mr. Rose to be shown the draft judgment? He's been the client's agent. He's not an officer or an employee of the applicant, but he's the one who gave evidence at the tribunal. He's present in court today, and I would like permission for him to be able to see
No
the draft
objection.
On
judgment.
that basis, yes. Thank you very much indeed.
All right, indeed.